Welcome to the Judicial Committee of the Privy Council. Today we're hearing the appeal in the case of Richards against the Public Service Commission, which is an appeal from the Court of Appeal of Trinidad and Tobago. The issue in the appeal is whether the appellant, Mr. Richards, was treated unfairly when suspended from duty on full pay by the respondent, the Public Services Commission, pending an investigation as to the circumstances surrounding the loss of his firearm, without first taking into account his written explanation of those circumstances. The appellant appears by Mr. Maharaj, Senior Counsel, Mr. Strang, Alvin Ramroop, and Kingsley Walesby, and the respondent appears by Thomas Rowe, Queen's Counsel. I am Lord Briggs. Sitting with me are Lady Arden.
Good day, everyone.
Lord Sales. Hello. Lord Leggett.
Hello.
And Lady Rose.
Hello.
We will take a short break of 5 to 10 minutes at the end of the submissions of Mr. Maharaj, but you'll need to leave your screens or at least your connection on, even if you close your video screens during that period. Thank you. Mr. Maharaj.
Much obliged, my lords and my ladies. My lords and my ladies, at the heart of this appeal is the issue whether the Court of Appeal properly appreciated the requirements of the duty of fairness and the other duties imposed by law on a public decision maker. And in particular, whether the Court of Appeal properly understood, as the judge did, that what the duty of fairness requires in each case depends on the facts and circumstances of the particular case. In my submission, the Court of Appeal, led by an erroneous construction of the regulatory scheme, wrongly disregarded the facts and circumstances of the present case. A further issue that arises is whether the Court of Appeal gave adequate regard to the supervisory role of the court in judicial review. The Court of Appeal, finding that the regulations have a process which required the Respondent Commission in its discretion to form an opinion, ruled that there could be no basis for criticizing the Commission's exercise of its discretion as unfair. That approach, my lords and my ladies, was wrong in law. It would have the effect of insulating the Commission from review on proper public law grounds. My lords and my ladies, I intend to make my submissions to the board in the following structure. First, I would give an overview of the overall requirements of the Commission in making the decision to suspend the appellant. Secondly, I would give a chronology of the relevant facts. Thirdly, I would deal with the judge's decision and reasoning. And fourthly, I would deal with the Court of Appeal's principal reasons for overruling the judge and why they are wrong in law. Fifthly, I would briefly deal with the respondent's raising of the presumption of regularity. The Court of Appeal did not rely on that presumption to set aside the findings of the learned judge. Perhaps ordinarily, this would be a matter for reply, but as I wish to refer in my reply in the bundle of authorities to passages which are not referred to in my written case, I propose to deal with this point so that Mr. Rowe, my learned friend Mr. Rowe, can see what passages I rely on. I would first like to deal with the overview of the relevant requirements of the Commission in making the decision to suspend the appellant. A decision to suspend an officer from duty pending investigation need not entail a finding of guilt, but it can have a significant and substantial impact upon the officer concerned, as it did in this case with respect to the appellant. The terms of the suspension of the appellant can be found at page 74 of the electronic bundle, and it's a letter addressed to the appellant from the Commission of Prisons. And the board would see that he was required to return his uniform, his prison identification card, his pocket diary. He was forbidden from leaving the country without permission, and he was required to report weekly to the prison service. In his affidavit, he gave evidence as to the impact on him. At page 403 of the electronic bundle at paragraph 56, he suffered stress, he suffered the stigma and heard much negative media comment about him at paragraph 56. At page 413, at paragraph 59, he suffered stress and shame. At paragraph 41, at paragraph 59, sorry, and 60 at page 414, he was hindered in doing his job as president of the Prison Officers Association. And he was unable to obtain loans from the banks. That is at paragraph 61 on page 14, at page 414. And at paragraph 68 and 69, at pages 68 and 69 of the electronic bundle, the board would notice that his suspension was published in the media, headline news. The Respondent Commission decided to suspend the appellant in the exercise of its powers under Regulation 88(1), and we can find that at paragraph 1438 of the electronic bundle. Page 1438 of the electronic bundle. And the board would see at Regulation 88(1), the power of suspension, for the power of suspension to arise, the commission had to be of the opinion that the public interest of the repute of the public service, the public interest or the repute of the public service required the appellant to cease reporting for duty until further notice. I respectfully submit that the requirements of a public body making such a decision are well established. But I will refer to two of those requirements. The first requirement is that the commission was required to act fairly towards the appellant. In Trinidad and Tobago, this is not only a requirement of the common law. It is laid down in statute by Section 20 of the Judicial Review Act at page 1410 of the electronic bundle. And it says that a public body has a duty to exercise that duty or perform that function in accordance with the principles of natural justice or in a fair manner. In Trinidad and Tobago, it is also a constitutional right, as now it is well established that the individual's constitutional right to the protection of the law includes a right to a fair treatment by public authority. The second requirement I would like to refer to is that the Commission was bound to take reasonable steps to acquaint itself with information that is material and relevant to its decision. In other words, given the information that an officer is being investigated over allegations of misconduct and faced with the question whether its powers under Regulation 88(1) are engaged, and whether it ought to exercise them, it would seem to me that the Commission should ask itself some of these questions. What do we know about it? What do we need to know to act fairly and make a proper decision on the criteria? What information do we have available about the circumstances of the alleged offense, about the present circumstances, about the officer involved? It is my respectful submission, there is nothing remotely remarkable or exceptional about those requirements. They are not onerous or impractical. They are what the law would impose upon any public body making a decision which has significant effects on the life of an individual. In the particular circumstances of this case, the judge decided that the Commission had not acted fairly or lawfully when it decided to suspend the appellant because it did not consider relevant information which it knew or ought to have known was available in the form of a statement made by the appellant to the investigating officer, and also a letter sent by the appellant's attorneys at law to the Commission, in which the attorney at law exhibited the statement made by the appellant to the investigating officer. Moreover,
sorry, can I just ask you at this point? An oddity of the facts that were presented with in this case is that we know the investigating officer produced his report about 2 weeks after the suspension, if not sooner than that. And one would expect under the procedure that at that stage there would have been a decision taken whether to charge Mr. Richards, and if so, whether to continue the suspension or not. Did that happen?
no, my lord, what happened is that the suspension continued, and later in the proceedings, before the matter was heard in the Court of Appeal, the Commission discontinued all disciplinary proceedings.
But was that charge, a disciplinary charge, preferred?
My recollection is that he was ultimately charged, but the proceedings were discontinued just before the matter was in the Court of Appeal.
It just seems strange that we are discussing what was meant to be an interim temporary measure until proper information available in the form of the investigating officer's report, at which point there would have been a charge decision, and there ought to have been a decision whether to continue the suspension or not, pending the outcome of the charges. And yet, for all we know, it's just continued like this for 2 years. We just haven't been given the full story.
Yes, my lord, the suspension continued until just before the hearing in the Court of Appeal.
But if there was no consideration of it, you might have been on better ground bringing your challenge on that basis. That what you're trying to do is to challenge what was a temporary measure before the investigating officer's report was even available. There obviously then needed to be a full consideration of whether it should continue once his report was available. And at that point, your client had a right for his information to be taken into account too.
Yes, my lord. So,
complaints that didn't happen.
That didn't happen, my lord. What happened, and I would probably get my juniors to help me with the information to the board. What happened is that the suspension continued, and he was suspended until just before the hearing of the Court of Appeal. And there was no determination, as far as I know from the record, as to whether the charges ought to have been laid. I don't think there were any charges laid, but I can check that, and I can, in my submissions, I will let the board know that, my lord.
Well, I think linked to that is the question of whether the suspension, which lasted for 2 years, was entirely under Regulation 88, or whether at some point it moved to be an interdiction under Regulation 89. I think it would be useful for us to know that as well. Which is
I think I can assist the board with that. I think it continued under Regulation 88, but I will also assist the board with that before I take my seat, my lady. So my lords and my lady, moreover, the judge found all the commission had before it were the bare allegations against the appellant, and it based its decision to suspend on those allegations alone, from which the judge rightly inferred that the commission decision was based on a general policy and not on a case-by-case consideration of the circumstances of the case. We submit that these were sound criticism in law based on the circumstances of the appellant's case. I will next go to the chronology of the relevant facts. I think the chronology of the facts of this case is important context to the judge's decision and what was required of the commission in the particular circumstances of the case. At page 403 of the electronic bundle, at paragraph 18, the board would see that the appellant properly secured his firearm and ammunition in a locked safety box and secured his premises. A photocopy of that box is at page 55 of the electronic bundle. You will see it has a double lock mechanism. At page 404 of the electronic bundle, at paragraph 23, he discovered that his home had been burglared and the locked safe box containing his firearm had been stolen. At paragraph 23 and 24, one would see that having discovered that, he reported the matter to the police the same day. Although there was no direct evidence of findings about it according to his letter of the 19th of July, however, the appellant immediately reported the matter to the prison service. His letter is at page 63 of the electronic bundle. There was no evidence as to what the prison service did in response to this initial information, but what we know from the armorer that he learned about the theft from the appellant in April 2016. That can be found at...
Sorry, Maharaj, at page 63 is not, as far as I can see, any evidence of an immediate report to the prison service.
I'm sorry, my lord?
You gave us a reference to page 63, if I heard you correctly. And you
Yes.
said that was evidence that Mr. Richards reported the loss of the firearm straight away to the prison service.
Yes, that paragraph 23 on page 404.
He's saying there that he did so. Is that the point?
Yes, but that was not disputed, my lord. And at paragraph 24 at page 404, he reported it to the police station. That also was not disputed. And at page 63, in his letter to the investigator, at page 63, at number 3, he said he immediately reported the said items were stolen to the Trinidad and Tobago Police Service and to the Trinidad and Tobago Prison Service. That's at page 63, my. And what I was saying, my lord, is that according to the armorer, at page 440 1, at paragraph 12, he said that sometime in April 2016, I met the claimant in the new ERU building on his way to give a statement to the ACP operations, and he informed me that his firearm was stolen. And the armorer informed the Commissioner of Prisons by letter dated the 9th of May 2016, and that is at 441, paragraph 13. And then after that, about 7 weeks later, the Commissioner of Prisons decided to investigate this as a possible misconduct in accordance with Regulation 90 of the Public Service Regulation. And you will see on the 28th of June 2016 at page 59, he wrote to the appellant to say that he had appointed an investigator. At the same time, according to the procedure laid down in Regulation 91 of the Public Service Regulation, the Commissioner of Prisons would have informed the Commission, and that can be found at page 1439, Regulation 90. And if I may read a part of it to the board, where report or allegation or indiscipline or misconduct by an officer is received, other than report or allegation of the indiscipline to which Regulation 85 applies, the permanent secretary or head of department shall report the matter to the director for the attention of the commission and concurrently warn the officer in writing of the report or allegation of indiscipline or misconduct. By letter dated the 11th of July 2016 at page 61, the investigating officer, in accordance with Regulation 93, gave the appellant notice of the allegation and of his opportunity to respond within 7 days. And that can be found at page 61 of the electronic bundle. The letter dated the 11th of July 2016 from the to Mr. Richards, to the appellant, from Mr. Alan Nanan, Assistant Superintendent of Prisoner. He was the investigator. The appellant received that letter on the 13th of July 2016 and responded to the allegations in writing by a letter dated the 19th of July 2016. And that can be found at page 63 of the electronic bundle. And the board would see in that letter, he said that he wished to be informed of which regulations you're alleging that I have been in breach of, because as you would notice from the allegations, the investigator did not state what regulations he was relying on. And he said, without prejudice to my right to make further representation respect to any allegations of breach of particular regulations, I wish to submit the following for the purposes of your investigation. And he mentioned that his pistol and ammunition were adequately secured in a safe at his locked residence. And on the 11th of March, he discovered his residence was broken into by persons unknown and that the items were stolen, and that he immediately reported the items were stolen to the Trinidad and Tobago Police Service. He had no way of knowing who stole the items, the present whereabouts. He have acted in accordance with the Firearms Act, and he sent a copy of this letter to the Director of Personnel Administration, Public Service Commission Department, and he reserved his rights to make further representation. Then the board would see that and by a letter of the same date, the attorney at law on his behalf wrote a letter which is at page 65 of the electronic bundle. That's dated the 19th of July also. And in that letter, at page 66 of the electronic bundle, he said, in this connection, please advise which particular regulations our client is alleged to have breached so that he may be in a position to fully respond. In any event, and entirely without prejudice to the right of our client to make further representation with respect to any allegations of breach of particular regulation, please find and close the statement submitted by our client, which we now invite the Service Commission to take into account. This statement establishes that our client's firearm, ammunition, and holster were properly and duly secured in a safe at his locked home. Our client was a victim of theft and was not guilty of any negligence or lack of care. In the circumstances, our position is that it would be unreasonable and irrational and would amount to an unreasonable, irregular, improper exercise of discretionary power to prefer any disciplinary charge against my client in relation to the theft of his firearm. If there are any facts or matters of consideration which might lead you to disagree with or to form a view contrary to the preceding paragraph, we would expect this consistent with your duties in public law and natural justice that you would inform our client of same so that he would have the opportunity of making further representations with regard to same.
Mr. Maharaj,
Yes.
do we have a copy of the statement which was closed? Where is that in the file?
Yes, my lord. The copy of the statement is what is on page 63.
I see. So it was a copy of the letter from the appellant himself, is that right?
My lord.
Yes, thank you.
That was his explanation, my lord.
So, do you see that there was anything new that was placed before the commission by the further letter from the attorney?
What I was coming to that, what the director, it was not placed before the commission. They said it was an administrative mix-up, and it was not placed before the commission. I was just about to come.
I think my lady was asking you whether it contained anything that they didn't already know.
Well,
The deed that said that it was in a safe and it was stolen.
they did not.
What difference that make to the decision to suspend him or not?
Yeah, my lord, what it is, they are saying that it was there, but they did not see it. But based on the regulation, they would have known that an investigation was in train.
So they knew what was being investigated was whether he was telling the truth or not.
My lord?
What was being investigated was whether he was telling the truth when he said he'd left in the safe and it had been stolen.
Yes, my lord. Yes, my lord.
And what good would a letter from him saying that that's what he did have done if it had been before the commission deciding whether to suspend him, pending the outcome of the investigation?
Yes, my lord. So it would have been important for the commission to seek to get the information as to what he said in order to determine whether they should have exercised the power to suspend.
What bit of difference would it have made to know? Or did they not know already? He told them already that it had been stolen.
But my lord, as you would see from the evidence, there were no guidelines as to how the firearm should be kept. And he was acting in accordance with the Firearms Act. And the Firearms Act, and from the evidence, which was not disputed, it was an accepted practice that if he stored a firearm in a safe, that was good enough, because under the Firearms Act, he was supposed to store it in a secure place. So the question which arose is, did he contravene any regulation or did he contravene any law? And if it is that he kept the firearm and the ammunition securely in a safe, then there was no basis for suspension. There was no basis that he committed any misconduct. So it was important, in my respectful view, for the commission to see what his explanation was in order to determine whether he committed any misconduct.
Raj, I'm not sure you quite responded to the question which we've been putting to you. Your client says that he immediately reported the theft of his firearm to the police and indeed to the prison authority, the Prison Services Commission, through the I think we have to infer through the armourer. And is there any evidence to show that he said anything different in his initial report than that which we see in this statement? The statement simply says, it was in a locked safe at my locked house, and the safe and the firearm were both stolen. The natural assumption is that's what he told the police on the day after the theft, and that's what the police would have told the authority, which then instituted the investigation. In other words, the question is, what was new in this statement that the authority didn't already have?
Well, my lord, the commission did not have any information. They did not even know what he said. They did not know what explanation he gave. They did not know that he said that he complied and he kept his ammunition safe. They had nothing at all about what response he made. So they did not have any idea. And that is it, that they made this decision based on the bare allegations without considering and making any inquiry as to what explanation he gave. So it is not that they knew in advance that the statement which he gave and the explanation which he gave, that was the explanation. They didn't have any idea of that.
But surely their role was to determine whether the public interest required his suspension. And if there were firearms missing, and a prison officer was the owner of it, did they not think that this was itself enough to justify suspension?
Well, my lady, depends upon the circumstances in which it was missing. But this is a case in which the commission did not know what he said to the investigator. It is the investigator was not communicated by the commission. So the commission did not know. So what happened? The commission made its decision based purely on the allegation. I could have understood if it is that the commission had what the investigator said and they had considered that. Well, then it was nothing new, but they had no information from the appellant as to his side of the story.
But they knew it was
it's expected that this decision will be taken before they know what the investigator has concluded.
Correct, my lord. They made a decision.
They don't expect to have anything from the investigator, nor do they expect to have anything from the opponent.
Well, they made a decision without considering whether what the investigator had or what was stated by the appellant. They made it on the bare allegations.
Well, do you say they should have contacted the investigator, even though there's no requirement for that, and that his report was going to be due in a week or two's time?
Well, our case is that if you are making a decision in which you are suspending someone in these circumstances, and you know that there was an investigation being conducted based on the regulation, and you know that the investigation was being continued, and you had to make a decision which would affect the rights and interests of this individual, fairness demanded that you would find out at least what explanation he gave to the investigator. It was open for them to do that. It was their duty to acquaint themselves with any relevant and material information in making that decision. This is not a case, my lords and my ladies, in which they knew what he said and it was a further and better particulars of what he said. They did not know that he did what was in accordance with established practice in safekeeping of his firearm.
Well, that was not for them to assess, was it? That was a matter for the investigating officer to advise once he had found out the fact. At this point, they knew there was an allegation of indiscipline and that it was sufficiently serious to cause the appointment of an investigating officer, and that the result of the investigation was not known.
Yes, my lord. It was the duty of it was the duty of the commission, if they were making a decision to suspend him, to make it fairly and not to act on their allegation.
What they had to do was to see what, in the circumstances with which they were faced, would constitute the course of action that was in the public interest. They had to recognise that there would be a dispute, but that the allegation was X. They would know the allegation.
But my lord, this was a case in which the commission knew that the investigation had been underway for about 6 weeks. They knew that the appellant had remained on duty, on continuing his duty. And they then had to make a decision whether to suspend him. So it seems to me that they had a duty to at least find out what was his explanation.
Mr. Maharaj, can I just check? Are you saying that the appellant gave a different explanation of the circumstances in which he lost his firearm to the armourer and to the police when he reported the matter? Did he give the same explanation?
No, my lord. What I'm saying is that the fact that the investigator was investigating, that information was not before the commission. So that the commission had no information as to his explanation.
To interrupt, could you focus on my question? Are you saying that the appellant gave a different explanation of circumstances in which his firearm was lost to the armourer and the police when he reported them from that which he gave in his letter at page 63? Or did he give the same explanation?
My lord, we do not have from the evidence what explanation he gave to the armourer. He merely stated that he lost his fire. What we do know, however, that the information he gave to the armourer would not be information to the commission, but he maintained the same allegation at all times. But the information he gave to the armourer was not information to the commission. The public service.
Someone has to alert the commission to the fact that something has gone wrong, otherwise the commission can't take any action. Sure, I've been proceeding on the basis that inference is that it was probably the armourer, if not then the local police, that alerted the commission to the fact that the firearm had gone missing and that there might be grounds for investigation. Is that not right?
No, my lord. There was no question in this case that the police had any suspicions of any offense being committed. There was no question at all on the case that was argued before the High Court and the Court of Appeal that the appellant did not comply with regulations and guidelines for the keeping of a fire.
Yes, Mr. Maharaj, I'm now, if I may say so, focusing on a different question. How do you say the commission learned about matters such that they decided to set up an investigation?
The commission would have learned about that based on the operation of Regulation 90, because when the Commissioner of Prisons informed the appellant that an investigator was appointed under Regulation 90, the Commissioner of Prisons had to also inform the Commission. So the Commission would have been informed of that by the Commissioner of Prisons from the time the investigator was appointed. But the Commission would not have known at that time what was stated by the appellant. And then,
and may I ask then, what do you say alerted to the Commissioner of Prisons to the fact that they should notify the Commission on Regulation 90?
I think what I can say, it seems as though when the armourer communicated to the Commissioner of Prisons, he then decided that it probably to investigate it as if there was any misconduct.
Right. And so I come back to my question. Are you saying that your client gave me different information to the armourer than that which he set out in his letter of the 19th of July, page 63? Or did he give the same account?
Well, it would seem that all of the appellant would have told Mr. The armourer is that his firearm was stolen, but he would not have known the circumstances of it being stolen. And that is why the Commissioner of Prisons appointed an investigator to obviously determine whether there was misconduct in the theft of the firearm.
All right, thank you.
Can I just ask a factual question? You look at the letter of the 19th of July, page 63. Under Mr. Richard's signature, it says CC, Director of Personnel Administration, Service Commissions Department. Now, what is that Service Commissions Department? Is that a prison thing, or is it? Okay. And he actually says he sent the copy to the Public Service Commissions Department. I must say, I'd rather assume that that was the same as the commission that exercises the power to suspend under Regulation 88, and that they had therefore had that letter, but what they hadn't had was the solicitor's letter with the copy of this letter attached. But now you seem to be saying that your case is that the commission, in exercising its power under Regulation 88, didn't have either the letter directly from Mr. Richard at page 63 or the letter from his solicitors at 65 attaching that same letter.
Yeah. If I may explain this, the Public Service Commission is an independent commission which is responsible for exercising disciplinary power. The Director of Personnel Administration, that is part of the administrative arm of the Public Service Commission. So what happened in this case, the letter went to the commission, but did not reach the members of the commission when they were making the decision to suspend. And I will come to show that the Director of Personnel Administration, the Acting Director of Personnel Administration, said that it did not reach them because of an administrative hiccup. So the commission, in making the decision to suspend, did not have either the appellant's letter or Mr. Saini's letter, which had a copy of that letter. And you would see from her affidavit, she said they merely considered on the bare allegations basically, and they made a decision to suspend. So the fact that the letter went to the commission, the administrative arm, it did not reach the commission itself.
Could I just ask a question?
And one needs to make a distinction between the Commission of Prisons and the commission itself. The commission is the Public Service Commission, and the Commissioner of Prison is a separate entity. He's not part of the commission. So that when I was, it may be that it is my fault, when I was saying that it was copied to the commission, it was copied to the administrative arm of the commission, but it was not in the bosom of the commission itself. So, and you would see from the, as I was now coming to that, you would see that the commission would have known in any event, because on the 2nd of August, the investigating officer wrote to the Public Service Commission, not the Commissioner of Prison, to the Public Service Commission, and he said that he had been appointed. If you look at page 458 of the electronic bundle, a letter dated the 22nd of August.
2nd of August or 22nd?
You see that letter of the 22nd of August?
No,
The investigating officer, Mr. Nanan.
I see a letter of the 2nd of August.
458, my lord.
Yes, I'm on 458, and it's a letter
Sorry,
of the 2nd.
my mistake. It's the 2nd of August. I'm sorry.
Yes.
I do apologize.
Okay.
2nd of August, the investigating officer wrote to the Director of Personnel Administration, which is the Public Service Commission by the administrative arm. He said that he had been appointed on the 11th of July and asked for further time to complete his investigation because he had not been able to contact the witnesses. So this is evidence that the commission, the Public Service Commission, would have known, because you would see later that the Public Service Commission granted him that extension of time. So the Public Service Commission would have known that there was an ongoing investigation into the allegation. And up to that time, the Public Service Commission did not have any statement from the appellant or any explanation from him. And then you would see that, bearing in mind that you would see then on the 23rd of August 2016 at page 431, in the affidavit of the Deputy Director of Personnel Administration, you would see at paragraph 8, at its meeting on the 23rd of August 2016, the Commission considered the said allegation and decided that the claimant be directed to cease to report for duty in accordance with Regulation 88 of the Public Service Commission Regulation. The Commission formed the view that the repute of the prison service and the public interest required it to direct that the claimant cease to report for duty until further notice from the Commission. And then you would see Mr. Saini did write to the Commission by letter dated the 19th of July, but because of an administrative oversight, the Commission did not respond to that letter. The letter was directed to the wrong section of the disciplinary unit. The unit is responsible for processing High Court matters. And then by letter of the 30th of August, wrote to the appellant directing him to cease to perform duty. I would ask the board to note at paragraph 8 that what the Commission said, the Commission formed the view that the repute of the prison service and the public interest required it to direct that the claimant cease to report for duty until further notice from the Commission. They made that decision without seeing the explanations of the appellant, without knowing what his explanations were, with just considering the bare allegation. And that is why, as the judge found, and a finding which was accepted by the Court of Appeal, the only material before the Commission was the bare allegation. And you would see.
Maharaj, I'm actually thinking that the Commission understood very well that that allegation was the subject of detailed investigation by an investigator who is expected to report shortly.
Yes, my lord. The investigator, by the regulations, has to investigate and report.
Well, if that's the case, why do you say the Commission itself had to cut the same investigation, but preempting the investigatory measures that were already on foot and were due to reach a final conclusion shortly?
Well, my lord, the investigator is investigating, but the commission, the investigator is not part of the commission. The investigator is investigating, and the investigator report will ultimately go to the commission. But under Regulation 88, it gives the discretion to the commission as to whether it should suspend an officer. And therefore, if the commission has to exercise its powers to suspend, and that exercise of that power would affect the interests of the appellant, then if the commission knows that an investigation is being conducted, it is not in all cases that they may decide not to suspend. But if it is that this officer is on duty continuing to function and nothing was done to suspend him for a period of about 6 months, and it is going to exercise the power to suspend, and you know that there's an investigation going on, it was not urgent for the commission to find out, well, I am going to make an order to suspend, which will have effects on an individual. Should I not, with fairness, find out at least what his explanation was? And if they had found out that, maybe the commission would have dealt with in the way they dealt, in which the commission ultimately dealt with, in seeing that there was no merit in the allegation, and they discontinued it. So the fact is, it is not that in every case the commission would have to look at a report and investigate a report. And what the judge decided in this case, he was clear, it's because of the particular facts and circumstances of this case. In other words, before the judge, there was the evidence that he did not breach any guidelines, he did not breach any law, he followed the law as to how to keep a firearm. And the judge had that before him. And the judge said, well, if it is that the commission was going to make such a decision, nothing would not fairness demanded in the particular facts and circumstances of this case to find out at least what the facts are and what he said in the context of the facts.
But isn't it the investigator who's going to investigate the facts and find out what they are? How can the commission do that just on the say-so of the appellant in a letter?
Well, my lord, it's not the facts that to find out whether he's guilty or not. It's the facts to find out whether, having regard to what the appellant is saying, whether it is reasonable to acquaint itself with the facts in order for it to make a decision to suspend.
Yes, I see. Thank you.
Mr. Maharaj, is it really the law of Trinidad and Tobago that you can keep a firearm adequately secured by putting it in a little portable safe normally used to contain money and passports, which you might think is the very first thing that a burglar in your house would choose to pick up and take away and open at his leisure in his own premises? I mean, I ask the question because my own limited experience is that if you want to keep a firearm in your house, you keep it in a gun cupboard which is firmly secured to a solid piece of the wall, which can't just be picked up and taken away.
Well, my lord, in this case, what the Firearms Act says, that as long as you keep it in a secure place, there is evidence before the court that the accepted practice was it could be kept in a secured place in a safe. And there was no issue before the court as to whether this was not a secured place or not.
Okay.
The
Right.
issue before the court, it was not raised at the High Court or at the Court of Appeal that this was an unsafe way of keeping the firearm. What was the issue before the court, the High Court and the Court of Appeal, was having regard to the bare allegation which were before the commission. Having regard to those bare allegations, should the commission, in exercising its duty in being fair, ought to have acquainted itself with what was happening with the investigation, ought to have asked for or tried to find out what the appellant was saying. The respondent has raised the issue of the security of the firearm, but in my respectful submission, and you would see that was not an issue before the High Court or the Court of Appeal.
Mr. Morocco,
That is a new issue.
sorry to interrupt, could I just ask a question? What sort of information would cause the Commission not to suspend? Because clearly they had to consider their discretion because it was going to be operated in the public interest. What sort of information in a case like this would lead them not to exercise the discretion?
But my lord, if they had considered what the appellant said, he was saying that he complied with all the rules in keeping his firearm. He acted in accordance with the Firearms Act. And they would have seen then that there was another side of the story. And the judge said that there was investigation which was underway for some time. And the commission could at least have asked what was known at that stage of the investigation.
But in fact, he'd complied with the requirements if they were as loose as you suggest, may not be the end of the story, because it may be being said, well, he had arrangement with someone else about this firearm. So he was away for a day.
Sorry, my lady, I didn't hear you.
It might be said the regulations or guidelines, I think you put it, for the storage of the armaments was very lax. And it was possible, even by complying with those guidelines, still to be in cahoots with somebody else about the destination of this arm. It wasn't a final answer to say, oh, I've kept it very purely in accordance with guidelines. There still had to be other issues to be considered.
Well, if the accepted practice, and it has not been disputed in the High Court, was that this was okay. It was not an issue in the High Court or the Court of Appeal. The question which is at issue is, did the Commission acted unfairly in making its decision without considering what the appellant had to say, having regard to the fact that there had been an investigation which they would have known, there would have been an explanation as to how these things happen. What we have here is a case in which a commission, a public authority, made a decision without considering what the appellant had to say. And the question which arises for determination is whether the Court of Appeal was right or wrong in doing that.
The discreditable, sorry. I didn't mean to talk across you, Mr. Maharaj.
Mr. Maharaj, we've been asking you an awful lot of questions. I suspect that, bearing in mind you've only got about 20 minutes to go, we ought to give you a bit of time to develop the rest of your submissions.
So the commission would have known that he had been gathering information, and given the timetable set down by Regulation 90, it could have anticipated that the investigating officer would be in possession of a response from the appellant. And I would advise, if there had been no response, that would also have been relevant information. The judge was not imposing a rule that in every case, the commission must wait for a preliminary report from the investigating officer. He was making the point that on the facts of this case, given that the investigation had already been underway for 6 weeks, the Commission would have known that there may be relevant information available to it, but it decided to proceed in ignorance of that. And I know a lot of time has been spent, but I would like to point out to a paragraph 73 of the judge's judgment at page 237. And I think it is important to see what he said. The Public Service Commission, in the court's view, ought to have been receptive to his representations thereon, as a matter of fairness, especially in this case for the following reason. The PSC was aware that an investigation was being conducted at the time it made the decision to suspend, but it proceeded to do so without at the least a preliminary report from the investigating officer. The PSC was unaware that Richards had provided an explanation in person to Nana, and so they failed to consider the explanation, not as to the truth of his consents, but to make a determination of whether, having regard to the fact that Richards was contending that he had properly secured the firearm and a third party broke into his home and stolen it, it was nonetheless in the public interest to suspend such an officer. At paragraph 74, of the judgment, the High Court, Justice Rahim, stated so that in the court's view, although there may be no right to be heard at this early stage, the question becomes one of whether in the circumstances of this particular case, fairness demanded that Richards be heard prior to the PSC taking the decision to suspend. When viewed in the context of the facts, it was clear that the Public Service Commission would have had available to it at least 2 representations for Richards, which were not considered. Those representations were relevant to the criteria to be applied by the Public Service Commission under Regulation 88. We submit that was a sound analysis of the learned judge. It is based on the proposition that although the regulations and Regulation 88 in particular do not require the Commission to hear from an officer prior to a decision to suspend him, the duties imposed by the principle of fairness and indeed other requirements of public law in the circumstances of a particular case require it to consider what the officer had to say. That proposition is not now, as I understand it, in dispute, so I would not take your lordship through the proposition and the authorities set out in my written case at paragraph 36 to 39. I want to deal, my lord, my lord, I know I only have 15 minutes upon regular time. Would I be given additional time, my lord?
See how we get on. Maharaj, we've asked you a lot of questions, but Mr. Rowe must be given time as well. Mr. Rowe, what's the minimum time you think you need?
I'm rather like my learned friend, my lord. It rather depends on how much stoppage time there is, as it were. But I'm certainly not. I'm certainly not sitting here agitating to be allowed to start precisely at the time allowed for. I appreciate there've been a lot of questions, and my learned friend must be allowed to develop his case.
Mr. Maharaj, I think we can probably let you go on at any rate until 2:30.
Much obliged, my lord. My lord, the Court of Appeal, however, disagreed with that proposition of the learned judge and disagreed with the judge's analysis. I will deal with what I submit at the Court of Appeal's 5 principal reasons in turn and set out why I say they were wrong in law. The first principal error, the Court of Appeal's primary reason for overruling the judge was that the regulations do not provide for a right to be heard prior to suspension. If there was no right to be heard, it followed, said the Court of Appeal, that there could be no duty on the Commission to consider any representations of the appellant. Paragraph 30 of the judgment of the Court of Appeal at paragraph 343, at page 343, says the regulations do not also contemplate a right to an additional hearing prior to a decision to suspend, unless such a right is demonstrated to be vested in the respondent. There cannot be its converse, a duty on the part of the appellant, whether based on fairness or natural justice, to afford him a hearing prior to a decision to suspend him. At paragraph 89, page 361, the Court of Appeal stated, further, this would be inconsistent with the judge's acceptance earlier of the authority of Murray, failing to take into account the attorney's letter and the officer's response were matters that the trial judge found went towards fairness. However, this could not be a breach of procedural fairness if, in fact, as he accepted under Regulation 88, there was no right to a hearing prior to suspension. The fact that such a material existed that was not taken into account cannot render the decision to suspend unfair if there was no right to have this material considered in the first place. The argument that fairness requires a right to be heard in the circumstances of this case, when the regulation themselves did not require such a hearing prior to suspension, is therefore inherently contradictory. The Court of Appeal in our submission at paragraph 89 is expressly saying the fact that the regulations do not provide for a right to a hearing prior to a decision to suspend excludes any possible argument that the circumstances of the case give rise to a duty to hear what the officer had to say. We submit that is wrong as a matter of logic and law. If the regulations do not provide for an officer's right to be heard, it does not follow that in no circumstances could a duty arise to consider what the officer has said. Indeed, the Court of Appeal's proposition is not defended by the respondent in this written case. My learned friend, Mr. Rowe, Queen's Counsel, at paragraph 21 and 22, at page 606, instead submits that the Court of Appeal did not say that a duty to consider representations could never arise. I respectfully submit that he is wrong. The Court of Appeal did say just that at the passage that I just read at paragraph 89. And when the Court of Appeal went on to reject the particular factors relied upon by the judge as giving rise to the duty to consider what the appellant said, it offered the same proposition as its main reason for doing so. At paragraph 100, page 365, the Court of Appeal stated, however, it is clear that once it is recognized that in this case there is no right to be heard at the early stage of the disciplinary process prior to suspension, none of the matters considered by the trial judge as justifying or requiring an additional duty of fairness in the peculiar circumstances of this case actually had that effect. There were therefore no peculiar factors in this particular case that required a deviation from the construction of Regulation 88 or its equivalent as decided in the case of Murray. The Court of Appeal, in our respectful submission, was not there assessing the particular factors identified by the judge and finding them insufficient to give rise to a duty on the part of the Commission. It was saying they could not have such an effect because there was no right to be heard. The second principal error made by the Court of Appeal is when the Court of Appeal did address the particular factors considered by the judge. The Court of Appeal rejected them for the same reason, namely that the regulations did not provide for the matters that the judge would have required. The Court of Appeal dealt with the judge's paragraph 73, which I read to your lordship in the passage beginning, and I wouldn't read it for your lordship, that's paragraph 82 at page 358. Paragraph 82 concerned the points made by the judge that the investigation was underway, but the Commission did not consider any preliminary report from the investigating officer. Paragraph 83 and 84 at page 359 concerned the fact that the Commission proceeded in ignorance of the statement given by the appellant to the investigating officer. Paragraphs 85 and 86 at page 360 concerned the fact that the Commission did not consider the letter sent to it by the appellant's attorney. In each case, the Court of Appeal gives the answer that the regulations do not provide for such material to be taken into account. See paragraphs 82.1, 84, and 86 of the Court of Appeal judgment. We submit this was an insufficient answer for the reasons which we have already stated. The third principal error of the Court of Appeal is that the Court of Appeal rejected the judge's conclusion on fairness and supported its proposition that the regulations excluded any possible duty to consider what the appellant had to say by finding that the regulations set out a comprehensive disciplinary procedure and taken as a whole were fair because they gave the appellant later opportunities to be heard in defense. See, for example, paragraph 79 at page 357 of the electronic bundle. I have set out other references in my written case at paragraph 66 and 66 to 70, pages 591 to 593. I submit that the reasoning was wrong. The statutory scheme is not so comprehensive as to exclude the possibility that a duty might arise at the suspension stage to hear what an officer had to say. In fact, there could not possibly be said to be a comprehensive statutory procedure for the decision to suspend because the regulation did not prescribe any procedure at all for that decision to be made. I would refer the board to the paragraph 47 to 55 of our written case, page 586 to 589 in the legal authorities which support our submission. And the decision to suspend an officer is a distinct matter with its own consequences, separate from any later decision on whether he's guilty of misconduct. The fact that he will be fairly heard on the question of his guilt, if it arises, we submit has no bearing on whether a duty might arise to hear him on the question of his suspension. In this regard, I would refer the board to the passage in the case of Burst and Callahan, that New Zealand case, page 1478 of the electronic bundle, in which the New Zealand Court of Appeal clearly expressed that distinction. At line 15, the Court of Appeal stated, "It is not a question of whether the officer is to have an opportunity of defending himself against the charge, but of whether pending the hearing and determination of the charge, he can be suspended without any prior opportunity to be heard as to that." The fourth principal error of the Court of Appeal is that the Court of Appeal rejected the judge's conclusion because it said he was imposing new burdensome requirements on the Commission in addition to the regulation and effectively redrafting the regulation. That reasoning is at paragraph 82, subparagraph 2, pages 358 to 359, and paragraph 88 at page 361. See also paragraph 72 at the top of page 356. We submit the Court of Appeal was wrong. The judge was not laying down any requirement on the Commission that it must always do the specific things he found were called for by the circumstances of this case. As I adverted to when reading the judge's reasoning, he expressly limited himself to the particular circumstances of the appellant's case. The judge was simply articulating what the general public law duties of the Commission required of it in the particular circumstances of that case. In my submission, he was imposing no burden greater than which the public law imposes on any decision maker. The fifth principal error, the Court of Appeal rejected the idea that any criticism of the Commission could be drawn from the fact that it considered only the bare allegations before deciding to suspend the appellant. We submit the judge rightly inferred that the Commission decision, therefore, appeared to be a matter of general policy rather than a case-by-case consideration. The Court of Appeal answer to that criticism was that it was a matter for the Commission discretion whether the public interest required the appellant suspension. See paragraph 92, page 362 of the Court of Appeal decision. At paragraph 93, it held that if the Commission had in its discretion found that the public interest required suspension, then there is no basis for the court to condemn the process as unfair. At paragraph 98 at page 364, the Commission's obligation is to consider the public interest or the repute of the public service, matters upon which it exercises a wide and sole discretion. The undisputed evidence is that it did so, when there were just bare allegations in our respective Commission. We submit that the last finding of the Court of Appeal is based on the bold statement in the evidence of the acting director that the Commission formed the view that the repute of the prison service and the public interest required it to suspend the appellant. I submit that the Court of Appeal's reasoning on this point was simply no answer to the judge's criticism. It is not in dispute that the question whether the public interest or the repute of the service required suspension is a matter for the Commission's opinion. But it does not follow, therefore, that all the court needs to know is that the Commission formed an opinion that the public interest and the repute of the service required suspension. The Commission was still bound to act fairly and take reasonable steps to inform itself of the relevant material. If it had done so, then its opinion would not be really open to challenge in court. But the questions whether, in coming to its opinion, it acted fairly and whether it took reasonable steps to inform itself are questions for the court. The Court of Appeal reasoning ignores the court's supervisory role. It will exclude the court from considering whether the Commission had complied with the duties imposed upon it in public law. In his written case on the presumption of regularity, I just want to say a few words on that. In his written case, Mr. Rowe, Queen's Counsel, has submitted that the presumption of regularity applies, which he says the following effect. First, he says that the judge overlooked the presumption of regularity when he said at paragraph 74 of his judgment that the duty lay with the Commission to demonstrate its reasons for its decision. The last sentence of the judge's paragraph 74, page 238 of the electronic form. I emphasize that the judge said that the duty lay with the Commission, not the burden as Mr. Rowe, Queen's Counsel, has put it. See paragraph 9 of the written submission of my learned friend at page 599. In my submission, the judge was there correctly stating the approach of the court in judicial review once leave has been granted to scrutinize the decision of a public body. The approach in Trinidad and Tobago was authority set out by Justice of Appeal Jamada in the case of the Police Service Commission and Graham. Having first referred to the judgment of John Donaldson in the Huddleston case, at page 993, Justice of Appeal Jamada went on at paragraphs 19 and 20 at page 994 of the electronic bundle, and I would read what he said. From these statements, that is reading from what was said in Huddleston, it is clear that once an applicant has satisfied a court that he is entitled to apply for judicial review, and once permission has been granted, the respondent owes a very high duty to the court to cooperate with it and to make available to the court all relevant facts and reasoning underlying the decision on the challenge. It is in this context of cooperation, where a court has granted leave to pursue judicial review, and where the full and candid disclosure of the claimant's evidence, as well as the full, frank, and uninhibited explanation with all primary documents relevant to the challenge, subject to lawful exemptions of the public authority and before the court, that the process of evaluation contemplated by judicial review is to be undertaken. And it is in this context that the presumption of regularity comes into play, as explained by Lord Caswell in Bagundin and the Attorney General. Therefore, as I sought to explain in Furlong and O'Brien, the presumption of regularity ought not to operate as a shield behind which the public authority can hide by refusing to give evidence on the basis that it's for the claimant to prove its case. This is an erroneous and misplaced view of how the presumption of regularity ought to operate in public law matters. Indeed, a presumption of bona fides ought to willingly lead to full disclosure of all relevant information at the earliest opportunity, including in response to pre-action. The second point, Mr. Rowe, Queen's Counsel said that paragraph 10 of his written case at page 601 is that the proper presumption is that the Commission, in good faith, knowing the terms of the allegations against the appellant, formed the opinion that the public interest and the repute of the service required it to suspend the appellant. That proposition does not take the matters any further. It is not in dispute that the Commission formed the opinion and it did so in good faith. The questions are whether in the circumstances it did so fairly and whether it could do so properly and fairly in ignorance of relevant material which it knew or ought to have known was available to it and which it would have found out on reasonable inquiries. It is certainly not the case that the presumption of regularity answers those questions, as they were the very questions before the court for review. There was plainly sufficient evidence to displace the presumption in that it was common ground that the Commission did not consider the appellant's representation, and indeed, as the judge found, considered only the bare allegation. The judge was entitled to consider the implication of those facts for the question whether the Commission fairly and properly took all relevant matters into account, and the presumption of regularity cannot therefore be used in the present case to repel the judge's criticism. Those are my submissions on the principal errors of the Court of Appeal, my lords and my ladies. For these reasons and those in my written case, I submit that the Court of Appeal was wrong to overturn the judge's findings and decision. The judge's reasoning was sound, and his decision, with the greatest respect, should be reinstated. Unless I can assist the board, those are my thoughts.
Very much indeed, Mr. Maharaj. Managed to finish slightly within the extension of time, but I think as Lord Leggett has a further question.
I'd like to ask you, if I may, Mr. Maharaj, about two rather odd documents in the bundle. The first one is at page 444.
At page what, my lord?
444. It's part of the armourer's evidence. The armourer exhibited this letter of the 3rd of February, reporting about the firearm inspection in January, at which two people, one of whom was Mr. Richards, had failed to turn up by repeated attempts. And then at 443, the previous page, there's a similar thing in February, at which Mr. Richards was the only person who didn't turn up. I mean, those letters do rather suggest that Mr. Richards really complained if his explanation as to how the firearm had come to be lost wasn't immediately accepted at face value.
My lord, the appellant, from my recollection, responded to this in his affidavit.
Well, I think he said he didn't know anything about the inspection, but that does seem a bit odd.
I think this has to do with the inspection of the firearm over a period of time. But looking at it, my lord, I do not think this has to do with the theft, if I may say so. I think what happened is that there was a requirement, separate and apart, for an officer to report his firearm on a regular basis. And there was evidence from the appellant that he did report, he did report he did report and he denied some of these things that were being said.
Yeah, all right. So it was an issue. It was an issue as to whether.
If I may say so, in any event, these matters, these matters had to do with the reporting on different issues as to how regular they would report the firearm that they the armor, but it did not have to do with the theft. Unless I am mistaken, but I am. And he was saying that the police were still investigating the matter. But you would see, as it did not arise, I did not put it in my submission. But if a person was negligent in securing his firearm, it was a criminal offense for which he could be prosecuted. And there was no police investigation in respect of this matter that he committed any offense or that he was in breach of any duty. It is true that his explanation was not immediately taken at face value, but the fact is that the explanation that he gave was not considered by the commission. These documents would show probably that the prison did not take his explanation at face value. But the issue in the case, if I may say with the greatest respect, both at the High Court and in the Court of Appeal, was really as to it was not considered by the commission. In the evidence before the board, you would see that there was evidence from my client to show that there was no misconduct. He denied all of these allegations, but there were no issue raised as that he was not speaking the truth or anything like that. And in his application for leave to apply for judicial review, he showed that there was no misconduct. He showed also that under the Firearms Act and the Firearms Regulation, he complied with the relevant law. And that is why both at the High Court and the Court of Appeal, that was not an issue in the case. The question is, should the commission, in the light of everything, have made this decision in the context of the facts without acquainting itself with the relevant material, which it knew it had an investigation going on, which would have assisted it one way or the other in making its decision to suspend.
Take our break stage. Keep your WebEx connection open, but you can obviously close down your sound screens. We'll resume at 2:40. The court is resumed. Mr. Rowe.
Thank you, my lord. My lord, my ladies, the essential difficulty I submit with the appellant's case is that it is accepted by the appellant that there is no general right to be heard before the commission makes a decision whether or not to suspend an officer. And although it's common ground that that's the position, it's perhaps worth taking a moment to consider why, in our respectful submission, that is a sound state of affairs. And we set this out in our written case. It's page 601 onwards. We set out there a number of reasons why, in our respectful submission, it's sensible and practicable that there should be at that stage no right to be heard. Our first point is perhaps an obvious one. Suspension is intended to be an interim temporary measure, and indeed, as we point out in the written case, it's required to be such, because if the suspension is allowed to go on for too long, then the officer who has been suspended will get a fairly sympathetic reception from the court if he or she goes along and says, "Well, my right to protection of the law has been infringed." And we see that, for example, from the Durity case, which we mentioned in our printed case. It's suspension on full pay. It doesn't itself imply or require any finding of guilt. That is not, of course, to deny the fact that when somebody is suspended from any office or, for that matter, employment, there will be those who are inclined to think that there must be a good reason for that and to think less of the person as a result. But that's unfortunately always the case when you have any arrangement whereby somebody is charged with something or accused of something, and there's time taken to decide whether the charge or the accusation is rightly made or not. It's not a reason for saying that there should be a right to be heard before suspension. And of course, the practicalities of it are simply that if there was to be a further stage imported into the process, that you've got a right to be heard before you were even suspended, the practicalities of it are that the suspension would be necessarily delayed, and there might well be cases where it's not in the public interest that the suspension should be delayed. Because it is, of course, the public interest and the repute of the public service which the regulation expressly refers to, and which there are therefore other considerations that need to be taken into account. We also make the point that, of course, legislation...
Mr. Rowe, can I ask you about the first point that you made, that suspension is intended to be an interim measure?
Yes.
I mean, strictly, Rule 80 doesn't say that. So, as I read the rules, you could actually have suspension which was not linked to some wider process of discipline. Perhaps imagine circumstances where some action is thought has to be taken, even pending a decision whether to start.
Yes, it's true.
That I've understood correctly.
Well, no, it's certainly true that what's required to trigger Regulation 88 is simply the Commission becoming, as it says, aware of any act of indiscipline or misconduct, and the Commission being of opinion, the public interest, etc. Act of indiscipline or misconduct plainly means alleged act, and I take the point that it doesn't expressly say there that it's intended to be only a temporary process. But the obvious role of suspension in the scheme of things is that it's a state of affairs that prevails pending determination as to what is to be done in a more long-lasting sense. And my point about the protection of the law is that whatever the regulations may say, the person who is suspended and then the thing is just left adrift with the suspension in place, but nothing progressing by way of retrospectively validating, as it were, the suspension, finding that yes, actually the person has committed an act of misconduct or indiscipline. In those circumstances, if that happens, then there's a valid complaint that the protection of the law has been withheld from the officer or employee if it's an employment case. Yes.
Would you accept that when a charge decision is taken, if there's a decision to bring charges, although it doesn't say so in Regulation 89, I think, it must be an obligation on the Commission to reconsider at that stage whether the suspension should continue, and to take into account in that stage everything that the person concerned has said as to why it should not?
Well, Lord, I think my answer to that probably is the same as it would be at really at any stage of the process, which is this: that there, as we've said in the written case, there is no right to be heard before a suspension takes effect. From which we say that it follows that it can't be automatically wrong to suspend somebody without hearing what they say, even if they said something unsolicited. But of course, the requirements of fairness being necessarily responsive to whatever the circumstances are of the particular case, there may be cases where something comes to the attention of the Commission such that fairness does require it to take that something into account. And that could be, I suppose that could be, yes, at the stage of charge. Suppose somebody is charged and their response to the charge is to say, well, actually, this charge is completely misconceived and I can demonstrate why very, very clearly. I gave the example in the written case of the cast iron alibi attested to by somebody of unimpeachable character. One can see at that stage that if it comes to the Commission's attention that there's something really quite out of the ordinary, that leads it to ought to lead the Commission to take the view that there's really nothing in this at all, then its initial decision to suspend perhaps requires to be reconsidered. And I think as I do in the case, I think I'd accept that theoretically that could even happen at an earlier stage. But my point is that there's nothing of that to that effect in the present case, because all we have in the present case is the allegation on the basis of which I submit the Commission were perfectly entitled to take the view that suspension was warranted. And the only complaint, the only real complaint is, well, you didn't take into account what was said in that letter, which in my submission doesn't really take matters any further forward. That's the difficulty with it.
Well, it does take matters further. I mean, you can only say it doesn't take matters any further forward. That depends on what they knew without having received those letters. And it seems to be accepted in the evidence of the acting director that they didn't know that his explanation was, well, I had put them in the safe and they've been stolen. Given the delay that there was between the time of the theft, and again, it seems that he did inform the prison service and the police about the theft at the time, he went on working for several weeks or months without any difficulty. The Commission knew that there was this investigation ongoing, and you still say, well, never mind, they're still perfectly capable of suspending him with all the very adverse consequences that has for him, without even needing to ask, well, what's going on with the investigation? What's he said?
Well, my lady, the difficulty with that, I respectfully submit, is that if it's accepted that there is no right to be heard prior to suspension, then for the board to say, well, yes, that's right, but actually they should have taken into account what he said. The difficulty with that is if that's what the board says, that effectively undermines the basic proposition that there is no right to be heard before suspension. Because if you say, well, there's no right to be heard, but obviously anything that you do say must be taken into account, and it's an error of law if the Commission doesn't take it into account, you're effectively saying, well, there is a right to be heard. That one can't really escape from that. The necessary consequence of saying, and this is what the Court of Appeal have said in the Murray case, and it's common ground between the parties that decision shouldn't be disturbed. It shouldn't be disturbed as a matter of how these regulations are to be interpreted. If you accept that that's the position, there is no right to be heard, then one can't really say, well, yes, but if somebody unsolicited makes some observation, then it's an error of law unless that observation is taken into account. Because as soon as you said that, you effectively said there is a right to be heard, because the Commission is bound to take into account what people say, and therefore people seeing that will say, well, we must make submissions. So it completely undermines the proposition. One does not right at that stage.
I thought you were accepting that there would be some circumstances in which if something came to their attention, they would have to take that into account.
Well,
suspending. So my question is, well, what is the test for whether they do or not, and what is the test for whether they correctly made that call or not? What is the test for reviewing the exercise of that?
Well, my lady, we're in the territory of fairness, and of course, notoriously, what fairness requires in any given case is a matter of fact. So it's difficult to state a test in terms of generality as to what is required. The basic proposition I submit is that given that there is no right to be heard, it follows that it's not an error of law in and of itself, as appears to be submitted by the appellant, to make a decision to suspend somebody in circumstances where they have made a representation without first considering that representation. And given that the appellant's case depends upon saying that it is an error of law in those circumstances, I say the appellant's case doesn't work. But if we look at the, and I mean, the reason for my my concession, as it were, that there may be some circumstances where fairness does require that the Commission take something into account that's been said unsolicited, is simply because one can't cater for every possible case, and courts are always reluctant to try to do so.
So, Ro, could
Yes.
I follow up from the question that Lord Legate? Might it not be said that if the Commission knows that there's been a full investigation and there is an investigator's report making findings, that at that stage they know that there is material which has been fully investigated in the proper way, that then bears upon any decision to continue the investigation, such that fairness would require this, and indeed rationality might require that they call that report and consider it to decide whether to continue the suspension. Would you accept that?
It depends on the facts, my lord. In the present case, the position, in a sense, I say it's a point in the respondent's favour, because in the present situation, that when the Commission had before them the decision whether to suspend or not, what they knew was that there was a detailed allegation of misconduct. I mean, it's quite a specific allegation, having left the firearm unattended for a period of 24 hours and failing to account for the firearm. They knew that there was sufficient, there had been considered by the prison authorities to be sufficient material there had been considered under the Public Service Commission regulations to be sufficient material to justify the commencement of an investigation, and they knew the investigation was underway. And in those circumstances, it wasn't really incumbent on them to say, well, let's go to the investigator and say, well, what's the position? They were expecting, presumably, the investigator to come back at some relatively near date in the future with the results of the investigation, which would say whether there was a charge or not. I could certainly see that at the point that the investigation came back, it might be said in some cases, well, that is a trigger for the Commission to reconsider the suspension, possibly. But that's not the situation in the present case, where the investigation is underway, and the whole scheme of the regulations is that it's the investigator who does the investigating. There is then a decision taken whether to charge. If there's a charge, there's the whole process of deciding whether the charge is made out, and we've given the references in our written case as to all of the respects in which at that stage there is ample opportunity for the officer to know what the charge is, and it's quite explicit that the charge has to be spelled out in very clear terms, and of course opportunity to be heard as to whether the charge is made out or not. But all that the Commission is concerned with at the stage that it took the decision that it took in the present case is whether, on the material then before it, the public interest and the repute of the prison service requires that the officer be suspended. And I can see it may be said, well, he hadn't been suspended up until that point, but that's in a sense that cuts both ways, and that, of course, one might say in the appellant's favour, well, one can infer from that there was actually no real difficulty with him continuing. One can see that was I suspect implicitly Lady Rose's point. But on the other hand, it could be said, well, actually, that's an unsatisfactory state of affairs. I mean, if one looks specifically at the alleged misconduct, it's page 61 in the record. It's explicitly that he left unattended for 24 hours his pistol with the 2 magazines with 26 rounds of ammunition and the holster. So it's not just in general terms you have become separated from your weapon, as to which there could be all sorts of explanations. It's that he left it unattended at his residence.
But that would be consistent with him just having left it on the kitchen table.
Well,
for anyone to pick up. In fact,
Well, that would be an extreme example of something that was obviously that was encompassed within that description, which is obviously wrong. I agree, but one infers from that the investigating officer, or those who appointed the investigating officer, considered that the mere fact of leaving it unattended at his residence for that period of 24 hours was in itself sufficient to warrant investigation. If one actually looks, my lord, my lords and my lady, at what the appellant himself says about the circumstances in which, on his account of things, this weapon came to be separated from him, and I say on his account of things because there is material in the background that does give some concern about his attitude generally towards looking after the weapon. But if one just looks at what he says, it isn't simply that he went out leaving it in the safe. It's quite a protracted period. If your lordships and your ladyships look at page 38 in the record, you'll see that he says at about 2 o'clock, when he's on the 10th of March, he's residing in Barataria, gets a call from the former Minister of Housing asking to attend a constituency office in Port of Spain about some housing that's going to be allocated to prison officers. He says he properly secured the valuables, including the service firearm, in what he calls the locked safe, but we've seen a photograph of it, and it's really a little, as it's described there, fire water chest, the box, helpfully with a handle attached to it, so it's portable. Puts it there and then goes out. And he doesn't go out for a brief period and then return straight away. He goes on to the meeting, paragraph 19, and he's told that, in fact, the meeting's been rescheduled to the next day. So he decides instead to go to Union Hall, San Fernando, in the next paragraph. 21, he says the prison's driver picked him up at 6 p.m. Went to Union Hall, San Fernando, returned to Trin City around 11 a.m. I think that must be 11 p.m. because he then says that he's asked to be dropped off at the residence of a friend in Camuto. And the prison driver dropped me off at Camuto. I overnighted by my friend. So knowing that he's left his property with the firearm in that little portable box, he decides to spend the night at a friend's house. And then he goes off the next day to a firing range and doesn't in fact get back home until 4:30 the next day. So that's his own case as to what happened, and his evidence, of course, as we've seen, his account of things, as we've seen, is that he, on arriving back at 4:30, found the thing, found the box stolen, and his evidence is page. I forget the page reference. It's the letter that he wrote. 61, I think, in which he, maybe 63, in which he describes the alleged misconduct. There he says he immediately reported it both to the police and to the prison service.
But did the commission have this statement before it or something along these lines?
The evidence is not very satisfactory. It's plain on the evidence, on the commission's evidence, that it did not have the letter from Mr. Saini, the lawyer, which attached this letter. The evidence is silent as to whether or not it got the copy that appears to have been sent directly.
No, I meant
by
the
the
statement
appellant.
that you were just reading as extracts from.
Yes, that's right. That's right. I mean, I go to the letter for present purpose.
That's surely a statement to the judicial review affidavit. The commission did that. I'm
sorry, I didn't quite hear your question.
Surely the statement you were just reading just at page 38 is the judicial review affidavit. The commission didn't have that statement.
I'm not sure, my lord, whether they would have done that. That is the statement. No,
they could possibly.
The thing I was reading first, that's the affidavit in support of the claim.
Yeah.
Yes. They obviously did have that information.
But are you saying that we should take into account now all that longer explanation but not take into account the fact that the thing was in a locked safe, which apparently complied with all the regulations that he was required to comply with.
Well, no, Melody, I'm not exactly saying that. There are 2 points there, I think. First of all, actually, there's no material either way in the evidence as to whether it complied with all the regulations, whatever they are. In fact, I mean, I'm not sure it's right to say there are regulations, but it's not in the record. But the Firearms Act itself simply says that the firearm needs to be secured. Oh, I think the firearms regulations say that. And the evidence of the respondent's evidence came from the armourer, who was Mr. Rudy Mahane, I think he's called, and that we can find in the record. If I take the board to it, it's at page 439. Rudy Mahays, or Mahaze, I don't know how it's pronounced. And what one can see there is paragraph 4 on page 439. He says, to his knowledge, up until January 2017, there was no written guidelines from the Commissioner of Prisons or his representative in relation to the overall carrying or securing of a firearm. The general procedure is that the Assistant Commissioner of Prisons Administration, who was the issuing officer at the time, would give the officer receiving the firearm a generalized lecture or talk on how to carry and secure the firearm at home. My point about this, to answer Lady Rose's question, is that the allegation of misconduct clearly implicitly proceeds on the basis that it is in itself misconduct to leave the item unattended at the residence for the period of 24 hours. And one can understand, I respectfully submit, why that would be, in a sense, regardless of the extent to which one has taken precautions to secure it within the residence, whether that's leaving it on the kitchen table or locking it in a really proper safe that's actually built into the premises in some way, so it can't be picked up. I'm sorry, I didn't notice that Lord Sales had his hand up.
No, not at all. Mr. Oak, can you help us with what evidence there is about a complaint that triggered all the Commissioner of Prisons and the Commission to take action in this case? I think it's the Commissioner of Prisons that does something first. They appoint the investigating officer.
Sorry, I'm very sorry, but I didn't quite hear that. It broke up for a second.
Oh, I'm so sorry. I think it was the Commissioner of Prisons that took action first, because I believe they appointed the investigating officer. And then they also notified the Commission. And the question is really, what evidence do we have available to us as to what prompted both the Commissioner of Police and the Commission to take the procedural step they did?
Don't you give me a moment? I'll see if I can locate the reference. At least some of the evidence that's before the court is at page 430. That's the affidavit of Marcia Pyler Brady, Deputy Director of Personnel Administration at the Public Services Commission, the Public Service Commission's Department.
What does she say?
She says, paragraph 7, by letter dated the 2nd of August 2016, Mr. Alan Nanan, Assistant Superintendent of Prisons, acting, informed the Commission that he was appointed as investigating officer by the Commissioner of Prisons to investigate allegations of misconduct made against the prison officer. And they then, the affidavit then goes on to say the Commission became aware of an allegation of misconduct against the claimant, and then it sets out in terms the same wording that we saw at page 61 a few minutes ago. Leaving
So are you saying the evidence is that the Commission only learn about the investigation, the charges, from this letter of the 2nd of August?
That appears to be the evidence, yes. So the position therefore does appear to be on the evidence As I say, it's unsatisfactory because there doesn't appear to be any evidence either way to account for what happened to the letter that was sent apparently directly by the appellant. But the position appears to be that the material that was before the commission was the fact that there had been this allegation made, and that the appellant was under investigation for that alleged misconduct. And it was in those circumstances that the commission decided that it was, in their view, appropriate, bearing in mind the repute of the prison service and the public interest, to direct that he did not report for duty. So that's the state of affairs as at that stage. And my lord and my lady, my submission is simply that if one once accepts that there is no entitlement to be heard, then the corollary is, at that stage, the corollary is that the system does not envisage that before the decision to suspend, there is to be any process by which the commission is presented with and considers material from the person under investigation, saying, well, I shouldn't be under investigation, or if I am under investigation, I should be acquitted ultimately because I am innocent for the following reasons. It's sufficient for present purposes that there is an allegation.
Would your position be different if the commission had been aware at the time it took its decision that he had written to the commission and his lawyer had, but they chose not to read what he had to say?
My lord, I think I would. My submission, I think, would be that they would be. Well, it's difficult to say they should choose not to read what he had to say. I think your lordship's question, if I may respectfully say so, presents something of a trap for me, because plainly, it's difficult for me to say. Just as that they should refuse to hear somebody. I mean, it's rather like if one imagines. In the days when your lordships and your ladyships were sitting at first instance hearing an ex parte case where, just as you're about to give judgment, having heard one side, somebody appears at the door of the court and says, I'm the defendant and I want to say something. I mean, it's an exercise of judgment at that stage as to whether you say, well, I've heard all the submissions and I'm about to give my judgment, it's too late, or whether you say, well, all right, I'll hear what you have to say. I mean, I can't say that in every case it would invariably be sound on the part of the judge in that analogy, or the commission on the facts of the present case, to say we will decline to hear what it is you've had to say. But I do submit that the problem with the appellant's case is that necessarily, by virtue of the I would submit pretty anodyne nature of what it was that he said, he is inviting the board to say effectively that the rule about not being entitled to be heard isn't really a rule, because it can always be circumvented. I'm sorry, I didn't notice that you had your hand up.
I struggle to see how, in Lord Leggett's example, the commission could refuse to look at the letter. You yourself accept that sometimes something might be said which is complete answer, which the commission should accept at suspension stage. How does it know, without looking at the letter, that it's not dealing with a complete answer case?
Well, my lord, I accept there's certainly force in that point, because, as your lordship says, if it didn't look at it, it wouldn't know whether there was force in it or not.
Right. So how does that live with the point that you were making? If we say that people can make representations and the commission has to look at them if they do, that is inconsistent with the absence of your major point you started. Because you now seem to be accepting that, yes, if someone writes in and the commission knows about it, the commission will have to look at that letter.
Well, my lord, the difficulty is that the general, the moment one accepts in a case like the present that there is a right to be, that there was that the appellant was deprived of a right to be heard that he ought to have had, one is fundamentally undermining the proposition that there is no right to be heard at that stage, which, for the reasons I've given, is a sound proposition. And so my point is that one should never say never. And of course, there might be a case where on the facts, fairness, as I've submitted already, and as is trite, is in every case dependent on the precise facts. And one can see that there might be a case, arguably, in which the facts are so extreme that a refusal to take something into account, even though there's no right to say it, is enough to render a decision unfair or irrational. One can see that, of course. But this is not that case.
Sorry, my question was a principled one.
Yes.
How does the Commission know it's not that case in circumstances where someone has written in, make representations, if the Commission doesn't look at the representations?
Well, the Commission didn't take a positive decision in the present case not to look at the representations. There was on the evidence, there was an administrative error, which meant that it never actually got to the, although in a sense it got to the Commission because it went to the office, or the Commission and all of their attendant staff working. It didn't actually get to the people who made the decision. And that's just, and I submit that's just in circumstances where there is no right to be heard in any event. That's just one of those things. I mean, if one imagines, it goes back to my analogy of the judge hearing the ex parte case. What if somebody's written in, but the court staff just have misfiled it and it never actually reaches the judge? Can it be said that the judge's judgment was contrary to natural justice? No, in my submission, because
right. So
there was no right to be heard. Therefore, no expectation it would get to the court.
So suppose someone had written it with the cast iron type offence that you accept can exist, and the Commission, through administrative incompetence, had misfiled that representation. The representation which the Commission would be bound to accept, which the Commission itself has lost. What would happen in that situation?
I would submit in that case that there would be no basis for impugning the decision, because the reason for the Commission not looking at the document would simply be administrative error in circumstances where there is advisedly no process for people to make representations to the Commission. The extent of my concession is simply that if the Commission actually positively, as a matter of fact, the individuals who comprise the Commission become aware that something has been said to them, which would make all the difference, then it depending on exactly what that thing is and whether it really would make all the difference, it could be unfair or irrational to deliberately to shut their eyes to it. But that's the extent of it. But in the present case, where there is merely where the reason they don't see it is that it is an administrative error, I say that there is no breach there of the requirements of fairness and no irrationality.
Yes, thank you.
So, my lord, that essentially is the central point that I make, and I say that the danger in doing anything different, what's impossible to do in the present case of my submission is to accede to the appellant's appeal and say that he should have been heard what he said should have been taken into account, without fundamentally undermining the proposition that at this stage there is no right to be heard, which, for the reasons I've given, is an entirely sound proposition. And one can, in my submission, be reasonably comfortable that this is not a case where doing that will result in some practical injustice, when one considers what, in my submission, are all of the relevant circumstances of the case. Your lordships and your ladyship earlier referred to the evidence about the concern about the way in which historically the claimant had dealt with accounting for his weapon. That didn't in the end result in any charge against him, certainly no charge which ever came to anything. But it's nevertheless part of the background, and this is dealt with in the affidavit of the armourer, where there is reference to the failure on the part of Mr. Richards to be present for all of his inspections. This is page 440. that I think was
But
the.
did the commission
was
know
connected with
about
the document.
those previous incidents when they took the decision to suspend him?
No, my lady, they didn't, and I don't. I'm not.
Please don't mix up prejudicial material, which was not before the commission when they took the decision to suspend, when your case is that they're not required to look at any exculpatory material. So far, you took us to his statement, which we've since ascertained was subsequent to the commission's decision, and now you're taking us to other points which I think were not before the commission, so can't possibly have been a justification for their decision.
Maybe I'm certainly not mixing up material in that sense, and I
thought Mr. Rowe's submission was just that in any event there was no practical injustice, rather than saying that that material was material to the rightness or otherwise of the commission's decision. I don't understand your saying, Mr. Rowe, that we can take that material into account in terms of analysing whether the commission did or didn't act fairly. You're just talking about the outcome.
Absolutely, of course, my lord. Well, it's the outcome and the overall fairness of the outcome, and it's also this important point, which is that it illustrates the fact that where there is an allegation against a prison officer, as there was here, that he's left unattended at his residence for 24 hours on his own account, and that must have come from somewhere, presumably from his own account, this lethal weapon, together with 2 magazines full of bullets, effectively the means to kill numerous people. When on his own case, he has done that. The fact that he says subsequently that, well, that I secured it at my residence doesn't, in my submission, actually amount to a great deal, such that it illustrates in any way, and that the commission is under some obligation to consider material. To consider the material. What my point is, it shows that there's a variety of possible explanations, all of which needed to be investigated, and the commission could perfectly properly take the view, simply on the allegation that was made, that that he'd not accounted for his firearm, left it unattended for 24 hours. The commission could perfectly properly take the view that that warranted suspension, accepting, as it presumably must have done implicitly, that there might in due course be an explanation for all of this. But that doesn't undermine the validity of the suspension. So it's while I accept that conceptually there could be the case where the thing that is said unsolicited, which doesn't come to the commission's attention, was such that it totally knocked out the allegation, this case is certainly miles from that. That's all my point really goes to.
We have to assume, don't we, that the investigating officer did have the same statement that had been sent directly to him by the appellant, and hadn't thought fit, on the basis of that statement, to wrap up his investigation without making further inquiries.
Yes.
Yes.
Well, that must be right. That must be right.
But there's no suggestion, is there, that the letter which the appellant sent to the investigating officer went astray?
No.
No.
No. So your lordship, with respect, is right. We must assume that's what the investigating officer had, and as your lordship says, did not at that stage see fit to abandon the investigation. But I was actually just dealing with that material not only for the reasons we've just discussed, but also in fairness, just to flag up the reference that I think my learned friend had in mind when he said that there was a response to this on the part of the appellant, and this is at page, I think, 467 and following, where at paragraph 6.2, the appellant says that in reply to certain paragraphs of that affidavit, he says, first of all, they're irrelevant. He's in a sense making Lady Rose's point, perhaps. And then he goes on to give his explanation. He denies he didn't report for his monthly inspection.
Can I ask you, Mr. if somebody has a right to be heard, then clearly, if you give them the right, it's not an answer to say, oh well, what they would have said wouldn't have made any difference anyway. But is the position different? Do you say, well, we're not concerned with the right to be heard, but with a question of whether there was unfairness in the way that the appellant was actually treated? Are we entitled in this context to take account of the fact that if his statement had been looked at, it could possibly have altered the outcome of the decision at that stage of the process?
Well, my lord, my submission, yes. On ordinary principles, if it's quite plain that this couldn't have altered the decision, then in the ordinary way, the court won't grant any relief by way of judicial review. I think I'm right in saying, no doubt Mr. Maharaj will tell me I'm wrong, I think I'm right in saying the position in Trinidad is the same as it was in England and Wales until quite recently, where of course now it's been shifted slightly by statute. But fundamentally, as a matter of whether any relief should be granted, the answer is plainly yes. If it would have made no difference to the decision, then that must be right. It doesn't warrant relief being granted. And that is, I submit, the position that we're in, because if we actually go and look specifically at what was said, remind ourselves specifically what was said again by the appellant, he actually there gives an extremely brief account of matters, back to page 63. He just says adequately secured in a safe at my locked residence. I mean, in a sense, that's actually a bit of an overstatement. To call that little box a safe is stretching things a bit. And he says he discovered that it had been broken into by persons unknown to me, and the aforementioned items were stolen, and he reported it to the police. He doesn't, as a matter of fact, explain that in the course of he doesn't explain the surrounding circumstances, namely that he had decided to go out, and he decided to stay out overnight. And there's no suggestion that he was, at the time he decided to stay out overnight, that he was miles and miles away from his home so that he couldn't get, forgive me, Lady Rose,
Well, he decided to go out because he was summoned by the former Minister of Housing to a meeting. Now, if that meeting had actually taken place and had been what had kept him out, we don't know when the theft took place. But assuming the theft had taken place within a few hours of him going out for a minister to meet a minister, would that ought the commission to have known about that, if that had been the case, before deciding whether to suspend?
Well, my lady, my point is that he doesn't give. My point is here, he himself does not give in this document, which he says failure to take into account. He says made this decision unfair. He himself does not give a detailed account. Of course, I accept the longer you go out. Well, I accept that theoretically, if you could go out for 10 minutes and somebody could break in while you're out. I'm not saying that I'm not suggesting that you should look. I mean, you shouldn't do it anyway, but I'm not suggesting that you should regard as in a prejudicial light against think ill of the appellant because he went out when he was asked to go out by the former minister. I think it was a former minister he went to see to discuss some allocation of housing in his capacity as a trade union representative. That isn't my point, but my point is that he would be on stronger ground in my submission if the representation that he had made, which he complains about not having been taken account of, was a full representation which set the whole thing out in detail. But actually he doesn't do that. He puts it all in pretty general terms, says it asserts that it was adequately secured in a safe at my locked residence. Well, even assuming that his account was accepted as true at all, and I've taken you to some material which casts some doubt upon his propensity to act properly with this weapon, though he denies it. So it's conceivable that actually this explanation isn't true at all. But even if the explanation is true as far as it goes, it still leaves a number of questions unanswered. What does he mean by adequately secured? That, in a sense, if you accept his explanation, is itself an issue that needs to be resolved. What did he really secure the thing adequately? But my point is that what we now know, which he didn't tell the commission in this document, albeit it never got to the commission, but it's relevant to my point as to whether it would make any difference. What he didn't say actually is that he went out and took a conscious decision when he was out at 11 p.m. Having finished everything he needed to do for the day. He took a conscious decision not to go home where the gun was, but to spend the night elsewhere. And there's no reason to think that. There's no reason to think that
what he doesn't say isn't really isn't the point. Your point is simply, surely, that this is so sparse, this piece of paper, that it couldn't possibly made a difference to the decision of the committee.
Yes, that's I put it. Your lordship's put it succinctly. I put it rather long-windedly. You're right. That's precisely my point. But I suppose I'm referring to the evidence that's he now gives as to what he did. Not because I say that the commission knew about it, because we know that they didn't. But simply to point out that everything he says in this statement could be true, and yet, as we know from his own evidence, it could be by no means the full story. And we know from his own evidence that, in fact, it was by no means the full story.
We know, don't we, that the letter to the commission, which was misfiled, contained as a sort of attachment the appellant's letter to the investigating officer, from which the commission, if the letter had not been misfiled, would have known that the investigating officer had received that explanation, and from the investigating officer's letter of the 2nd of August, that had not caused the investigating officer to put an end to the investigation.
Yes.
Yeah.
Well, that's right. And your lordship refers to the letter from the attorney. That's the one, of course, which is at page 65.
Yes.
And it doesn't really go any further. It's subject, I would submit, to the same points that I've just made about the appellant's letter, the appellant's own letter. I mean, he just refers to the statement. He complains about not being referred. Well, he asks to be referred to particular regulations, but in fact, the charges themselves adopt verbatim the language of the conduct regulations, and then just says in the middle paragraph, the statement establishes that our client's firearm, ammunition, and holster were properly and duly secured in a safe at his locked home. Our client, the victim of theft, was not given any negligence or lack of care. Well, that was just that was really barely more than a bare assertion. Well, I'm not guilty of any wrongdoing. And one can almost take it as read that the commission must have appreciated, when considering whether to suspend, that the appellant was saying that he was saying that he wasn't guilty of any wrongdoing. This would be a much stronger case if there had been some really powerful thing that had been said that showed that he really wasn't guilty of any wrongdoing. But as we've seen, there wasn't. So for those reasons, my lord, we respectfully submit that there is really no basis for saying that the decision to suspend was unfair. There's been reference to the fact that there was a long period during which the appellant was subject to suspension. I don't know whether it worked. I attempted earlier on to circulate the page reference that I think supplies the answer to your lordship's question to my learned friend about the date on which the suspension was lifted. But it's page 251, where in July 2018, the suspension was lifted, and it was decided that no further disciplinary action was to be taken.
Are you able to help us as to whether the suspension throughout was under Regulation 88, or whether at some point it moved to an interdiction under Regulation 88?
There's nothing which positively says it wasn't an interdiction at some stage, but it doesn't look as if there's any reason to think there was an interdiction. It wouldn't have been referred to as a suspension, one wouldn't have thought, in the letter on page 251 in July 2018, if at some point it had been changed to an interdiction. So from that, one infers that it must have been suspension all the way through. And of course, insofar as there is any implicit criticism of the commission for having kept the appellant under suspension for the period that it did, well, that's a different issue. That's not what was challenged in the present proceedings, which are exclusively a challenge to the initial decision to suspend. So that doesn't arise. And as I've shown the board, and the board is obviously well aware, if a suspension is continued for too long without anything being done to prosecute a disciplinary charge against someone, then that in itself can give rise to a complaint that the protection of the law has been withheld from that person, and there's a complaint under the Constitution to that effect.
We don't know, do we, when the charges were preferred against it?
I probably should be able to answer that question. I can't impress off the top of my head, but I'm sure I can. Well, the charges themselves are attached, I think, at the next.
I know, but they don't have a date.
They don't have a date on, no. I can't recall whether we've put that in the statement of facts and issues. I don't think we did, but
probably you don't know.
No, I don't know, I'm afraid. My lord, that essentially is the respondent's case. There are a number of specific criticisms of the Court of Appeal's way of looking at things that my learned friend makes in his written case, and we respond to in our written case. But I'm not sure there's a great advantage, unless there are any particular points that are troubling the board, in my going through all of that in detail. I do say that essentially the reasoning of the Court of Appeal was along the lines that I now put forward, namely that there is no general right to be heard, and there is nothing peculiar in the facts of this case that gave rise to a right to be heard, and therefore the decision to suspend without hearing the appellant was not unlawful on the grounds of failure to hear him. And it follows from that, I submit, barring something pretty extraordinary, which the facts of this case do not reveal, it wasn't unfair or irrational to proceed in the way that the Commission proceeded.
Yes.
So, my lord, I think unless there's anything further that I could deal with, that's really all I want to say. I was going to say something about the presumption of regularity, but I think, unless I've misunderstood it, and I'm sure my friend will tell me if I have, that it's essentially accepted now that the Commission did not take this decision simply as a matter of policy, that they always suspended people against whom charges were made. That seems to be at one point what the judge was saying, which is why I referred to the presumption of regularity. The presumption, in other words, in the present case, that the Commission approached in good faith, as we know, in fact, from a positive finding on the judge's part, in good faith, its task of deciding whether the public interest and the repute of the service required the suspension, and proceeded that way on the facts of the case as it believed them to be, rather than on the basis of any predisposition to suspend people regardless of the facts. That was the purpose for which I invoked the presumption of regularity. But since I don't think it's now being said by my learned friend that the Commission did anything other than that, I don't think I need to expand on that.
Well, thank you, Mr. Rowe. Mr. Maharaj.
A lot of the submissions that my learned friend Mr. Rowe made are submissions and matters which were not before the Commission. And I think I would want to concentrate and reply to my first point to mention that all that the Commission had before it was the bare allegation. And in the affidavit of Ms. Brady at page 431 at paragraph 8, she said, at its meeting on August 23, 2016, the Commission considered the said allegation and decided that the claimant ceased to report for duty. So the Commission has accepted that all that it had before it were the bare allegation. And the judge also found at paragraph 59 at page 231 that the report of Nanan was not before them, neither was the statement of Richards or the Saney letter. Now, my learned friend said that the Appellant statement would not have made a difference. How do we know it would not have made a difference? We don't know why the Commission thought the public interest required suspension. It's not immediately obvious why it did require suspension. So we would submit that it's not possible to say that the extra information would not have made a difference. A lot of the matters about the storage of the gun, about the circumstances of the theft, were not before the commission. That was not the issue. So I would like to make it clear that the finding that there were bare allegations, that was the judge's finding, and that finding was accepted by the Court of Appeal. In answer to Lord Legatt's and Lady Rose's question about whether there was a subsequent decision to charge and whether that entailed a further decision on suspension, the only evidence of that is from the acting director. She gives no evidence of any further decision or deliberation. But my junior in Trinidad has found that on the record that shows that on the 4th of August 2017, the charges were preferred against the appellant, but those charges were stayed. And then what happened was that the commission wrote on the 6th of July 2018, stating that they will not be proceeding with the charges and the suspension was lifted. That can be found at page 251 of the electronic bundle, and also that page 581 of the electronic bundle at paragraph 21 of the agreed fact. The judge decided on the particular fact of this case. The investigation has been underway for several weeks. The commission would therefore have known that there was relevant material availability, but it decided to proceed in ignorance of that and made its decision on the bare allegations alone. Our submission is not that the commission should have conducted an investigation. That was the job of the investigator. Our submission is that the commission could have asked what was the state of affairs, what were the facts, in order for it to make its decision as to whether it should suspend or not. My little friend, Mr. Rowe, accepts fairness depends on questions of fact in each case. The judge's assessment of the fairness and the fact of this case was an evaluation made by him, and we submit it is not to be disturbed unless the Court of Appeal shows the way in which the judge went wrong. The reasons the Court of Appeal gave for saying the judge went wrong were themselves wrong in law for the reasons which we have given. In respect of the submissions that my learned friend made, both written and oral, in respect of the theft and the circumstances of the theft, we submit that they are not relevant to the issues before the board, and they appear to be deployed with the greatest effect as mere prejudice. I make 3 points on this. First, the fact of the theft and the manner in which the appellant secured his firearm were not known to and were not considered by the commission when it made its decision to suspend it. Second, the commission eventually decided, in knowledge of all the facts, to drop the charges against the appellant. Evidently, it considered that the charges were not made out on the fact that Mr. Rowe now praised aiding against the appellant. Third, my lords and ladies, Mr. Rowe, Queen's Counsel, does not suggest what the appellant should have done. It was the appellant's unchallenged evidence that there were no guidelines given to him as to how to keep his firearm safe from unauthorized persons when he was not using it. And it has never been suggested that he's wrong when he said that what he did complied with the requirements of the Firearms Act. At pages 411 to 412, at paragraph 55, A to H, in his affidavit, which he filed on the 9th of December 2016, in his evidence in respect of the allegations of misconduct, he said inter alia that he was not provided with any guidelines for the safekeeping of his service firearm and ammunition. He said there were no rules and regulations for the safekeeping of any firearm. On 10th of March 2016, it was kept in a secure place. He stored the firearm, he said, in accordance with the Firearms Act. And upon discovering the theft, he immediately reported it to the police. And my learned friend, Mr. Rowe, referred to Mr. Mahase's affidavit at page 439, in which Mr. Mahase said that there were no guidelines. And at page 20 of the record, I think I should point this out to the board. At page 20 of the record, we see that, well, if I could take you at page 19 at paragraph 5, the applicant contends that based on the circumstance of this case, there is no evidence to show any fact of misconduct against the applicant. And then you will see at page 20, he referred to the regulation, the firearm regulation at paragraph 8, 9, and 10. That at paragraph 8, when they were not kept in an actual place with a view to preventing access to the service firearm, took reasonable care, and it's an accepted fact by the Trinidad and Tobago Police Service that a lock safe is considered as a secure place to store firearm and rounds of ammunition. And pursuant to Regulation 5, the applicant upon discovering, etc., etc. So the issue of the securing the firearm and safekeeping of the firearm was not an issue either in the High Court or in the Court of Appeal in respect of the decision to suspend. What was an issue in both courts was the question whether there was the principles of fairness demanded that have regard to the particular facts and circumstances of the case, that the commission ought to have acquainted itself to find out at least what was the present stage of the investigation and whether he gave an explanation or he did not give an explanation. It would have assisted them, but we are concerned about the procedure, and all these questions, with the greatest respect to my learned friend, did not arise and are not relevant to the issue in the case. May I just point out, my lord, my friend has relied heavily on there's no right to be heard and etc. I will ask the board to consider at paragraphs 44 onwards of our submission, of our written case, until 55, in which we dealt with those issues and the principles of law to show that based on the principles of law, the court, the commission had a duty in the circumstances, if fairness demanded, to acquaint itself with the relevant facts and to consider what the appellant had to say. And we are saying it is a right which have regard to the fact of this case that the appellant had. There's a question that Lord Leggett and Lord Sales asked about sending the letter to the director. Sending the letter to the director in our respectful submission is sending it to the commission. So the commission, in our respectful view, had the letter. The fact that the individual commissioners making the decision to suspend did not know of it does not mean that the commission did not know of it. The commission as a body should acquaint itself and should have tried to find out about it. The failure of the individuals to consider it in ignorance has the same effect as the decision by the commission not to consider it. To my lords and my ladies, unless I could assist the board in our respectful submission, the submissions of the respondent contained very irrelevant issues and did not deal with the issues in the case, especially that there were bare allegations and the commission made the decision on bare allegations. Unless I could assist the board with them.
Yes, Lady Upton has a question.
Thank you. I wonder if I could just ask this, Mr. Maharaja. If the commission had got all the material which you say they should have had in front of them, what exactly would they have done with it? Because they could see by looking at the statement on its face that there were many questions to be instigated.
But if the commission had the information before it, they would have known, or they would have had the view that the appellant complied with all the requirements that existed at the time for having his firearm and ammunition kept secured.
But does one come back to this point? He may not have told the entire story. He's told the story about storage, yes, and his absence from the residence, yes, but he hasn't explained everything else that there might be. And the investigator was presumably there to find out if there was anything.
Well, the commission could have asked questions. The commission could have written a letter to the appellant, whatever information it wanted. But the issue is the commission acted on their allegations, and they had an opportunity if they wanted to hear from the appellant.
But there would be another investigation, and would they not come up against the same point that had to be resolved in the investigation?
But it was not going to be another investigation. It would really be just getting what he has to say in relation to what was concerning them.
Yes, but that may not take him any further. Their responsibility was to the public interest.
We do not know what the commission would have done. The important thing is that he was denied the procedural fairness in having the commission consider his response.
Yep, I understand that. Thank you.
And I would ask that not only in Trinidad and Tobago you had the Section 20 of the Judicial Review Act, which in addition, which codified the common law of a public authority acting fairly and practicing the principles of natural justice.
Yes, indeed they must. Of course they must. And the ouster clause had gone. Thank you.
Well, if there are no other,
Yes, I have
yes, Lady Rose has a question.
Just going back to the interrelationship between Regulation 88 and 89 at 1438 and 1439. When I read them, I had rather thought that how it worked was that once it became clear that disciplinary proceedings or criminal proceedings are instituted, then they must move from Regulation 88 to the Regulation 89 situation. But I see that may be wrong, first because 89 is only relevant to disciplinary proceedings for the dismissal of the officer. But what I'm trying to get to is Mr. Rowe said, well, this is just a temporary thing. And it's different, it being an emergency thing from being a temporary thing. Because it seems that what you're saying, that even though charges were instituted, the suspension under Regulation 88 continued. And that may well have been right if the proceedings were not for his dismissal or criminal proceeding. Have I understood that correctly now?
Well, I think that your leadership is correct in the sense that if he was suspended under Regulation 88 and then proceedings were instituted, because the suspension would be pending the hearing and determination of the allegations and the disciplinary process. But we are saying that well, you have our submission, Mike. I think I should mention this. We ought to, in one of the cases I cited from New Zealand, one looking at such a case has to distinguish between the question of guilt ultimately and the question of suspension. At suspension stage, there is no question of guilt, but it's suspending pending suspending the determination, and the commission would obviously want to exercise its discretion, whether having regard to all the circumstances, it should make a decision to suspend or not to suspend. And what it is here is that it has to be answered why it is obvious that suspension was in the public interest, especially where this person was performing his duties for 6 months before the decision was made to suspend. Obviously, if he was given an opportunity of being heard, he would have been able to ask the question, well, why is it necessary now, if I perform the duties for 6 months, to be in the public interest, what it is in the public interest that you want to suspend me for? So it would seem to me, it would seem to me that where you have a situation where a person is performing his duties for 6 months and the commission doesn't think it is necessary to suspend him, and then you go and you suspend him without hearing him or without considering what he has to say, and you had to, and this was at a stage when the commission had not yet considered the question of interdiction under Regulation 89. So, if I may say with the greatest respect, if one takes out all the prejudice of the case, of storage and how it was kept, and the ammunition, how they were kept, when you look at it, was the judge correct that the fairness of this case demanded that there should be an opportunity to consider what the appellant had to say and acquaint itself before it made its decision to suspend, especially as this was an officer performing his duties in the public interest in spite of the impugned action?
Lord Thales has a question.
Yes, well, in fact, 2 points, if I may, Mr. Marriage. First of all, on information, page 251 of the bundle goes to some degree to this interaction between Regulation 88 and Regulation 89. Because we see from that is the notice of lifting of order of suspension. The disciplinary charges had been preferred by that time. We're not quite sure when, I think you gave us a date anyway. They had been preferred, but there remained outstanding a proposal to interdict from duty under Regulation 89. So no decision yet under Regulation 89. I think that the firm impression that one gets from that is that the suspension thus far had been under Regulation 88 and that the assumption was being made, and maybe we don't need to get into whether that assumption was right, that it is possible to suspend under Regulation 88 even after disciplinary charges have been brought, and even though those disciplinary charges potentially might involve dismissal as a sanction. I wonder whether you had any comment to make like that.
My lord, my only comment would be that at the time of making his decision to suspend, the point still arises that whatever the situation is, the commission had a duty to determine, well, to consider what representations were made by the appellant.
Then the second point I just wanted to raise with you, you made the point just now that the appellant had been continuing to perform his duties in this post for about 6 months by the time he suspended. But I think we've been shown now the evidence in Ms. O'Grady's affidavit that it's only on the 2nd of August that the commission learns that these charges have been brought against him. And Regulation 88, I would have thought, makes clear that it's the commission's decision, its opinion, as to the public interest or refusal of public service requires suspension. So I just wanted to check that you accept that So far as the Commission taking a decision is concerned, there's fairly minimal delay between the end of August and the 23rd of August for it to decide that in the fall of the allegations made, there should be a suspension under Regulation 88. Is that right, just as a fact?
But all that the Commission had on the 2nd of August were the allegations.
Yes, that's your answer. Yes, thank you.
Had the allegations, but they also had the fact that they were going to make a decision if they were going to suspend, that it would be in the public interest or the repute of the prison service to suspend him. But this was an officer who was performing his duties in spite of the impugned action. And therefore, fairness would have required to give him an opportunity to be able to say why, in spite of the allegations and in spite of you perform your duty for 6 months, why we should not suspend you in the public interest.
Yes, I understand. Thank you very much.
Well, I think you've dealt with all our questions, Mr. Maharaj. Thank you very much. I would like to thank both counsel and indeed the team of counsel assisting Mr. Maharaj for all their written and oral submissions on this case. The board will now take time to consider what decision it should make, and the court is now adjourned.